Yesterday, in an NBC News entrance poll, Iowa caucus goers were asked if Trump is convicted, is he fit to be president? 65% yes, but 31% said no. Now, whether or not that question will be put to the test is very much up in the air. Donald Trump's comically busy calendar has a number of potential court dates. We are still awaiting rulings that may affect the March 4th date of his federal election interference case in D.C., and the Mar-a-Lago case down in Florida may be the simplest case to try before the election. But some recent developments there have us all wondering what the judge is doing exactly and what it all means for Trump's scheduled May 20th trial date. Tonight, Trump's attorneys filed a 68-page motion, 68 pages, that has the potential to cause delay if Judge Cannon agrees with them. In the filing that was just put up an hour ago, they accused special counsel Jack Smith's office of colluding with the Biden White House. And on that basis, they are seeking a whole bunch of material, saying the special counsel's office is seeking to avert its eyes from exculpatory, discoverable evidence in the hands of senior officials at the White House, DOJ, and FBI, who provided guidance and assistance as this lawless mission proceeded. The court should conduct fact-finding on any disputed facts relating to the scope of the prosecution team, enter an order resolving the parties' dispute on that issue, and order the special counsel's office to produce the requested discovery. Joining me now is Joyce Vance, former U.S. attorney for the Northern District of Alabama. Joyce, thanks for being here. I literally just got this motion a minute ago, so I haven't had a chance to review it. But it sounds like Trump's lawyers want to greatly expand the number of people and the agencies that are deemed prosecution team in terms of the special counsel's office. Is that right?
That's right. This is a sort of fantastical narrative of Trump as the victim, done wrong by a weaponized executive branch that's out to get him. And so for starters, what he's saying, and this is an argument that there's debate back and forth about in discovery, to be frank, but he's saying that the prosecution limited the scope of their search for material they had to turn over to Trump far too narrowly. They want, for instance, the special counsel's office to go back to people in the Justice Department and the FBI. And perhaps that's warranted. You know, this is an 11th Circuit case, and the law in the 11th Circuit says that prosecutors have to talk to any agents who they worked closely with. That's the essence of the requirement. But then parts of this, other parts, are just completely out of bounds. They want the special counsel to go and work with the entire intelligence community to turn over everything in the intelligence community's possession that touches on anything to do with this. So I think the safe thing to say here is that we should wait for Jack Smith's response, which will undoubtedly be pretty harsh, given what the defense is requesting here.
This seems more than anything like a bit of theater to just delay this case. Would you say that's accurate? I mean, the idea that somehow the prosecutorial team extends to the entire intelligence community, the Secret Service, and the White House is, like, in a word, crazy, Joyce. But the question is, how seriously does Judge Cannon take something like this?
And that's the problem here, because Judge Cannon has never hesitated to put her thumb on the scales of justice for Trump. She's delayed this case to the point where it's really less and less clear that it's still even possible to try this case and get a verdict before the election. Now she's presented with the opportunity to delay things even further. And there are also questions about classified discovery. This could be where that May trial date goes off the rails.
It also sounds like in this filing, again, 68 pages, that President Trump is going to dispute at trial the contention from the special counsel's office that Mar-a-Lago was not secure and that there was a risk material stored at those premises could not be compromised. Joyce, I'm old enough to remember when we saw pictures of top secret or classified government documents being stored in a bathroom. It doesn't seem like a stretch to say the storage of these documents at Mar-a-Lago was not secure, but somehow Trump's team intends to argue that?
It's not, and it's not a defense. Trump wasn't entitled to possess classified material. Game over. It doesn't matter if he kept it in his bathroom, his ballroom, or if he had built himself a skiff and sent it there. He simply was not entitled to have this in the possession, and perhaps more importantly, the obstruction of the investigation that was an effort to reclaim it. Those are criminal acts. End of story.
It sounds to me, Joyce, that you're not very bullish on this trial getting underway before the summer or even potentially the election. Does it seem to you like the best hope for a federal case, a federal trial, is the Washington, D.C. election interference case?
So that all depends on the judge, on Eileen Cannon. The Mar-a-Lago case, the classified documents case, is not as complicated in many ways as the January 6th case, even though there are multiple defendants. Discovery could be completed in a couple of weeks. The case could be set for trial, and it could go on that May date. But it depends on whether Eileen Cannon wants it to or not.
Joyce Vance, always good to talk with you, especially as we have this big breaking legal news. Thank you for your time, Joyce.